Hey, Angela Langlotz, business and trademark law attorney here, and I am coming to you live like I do every weekday. If you like this video and you think other people might find it useful, please go ahead and share it to your friends. I got a call yesterday from a guy who was confused about registering a business name and trademarks and your rights, one vis-a-vis the other. So I wanted to cover that today. Many people, I get these same questions over and over again, so I like to go over these. Many people are really confused about whether or not when they register a business entity with the Secretary of State, whether or not they also have the right to use that name as a trademark. Well, it depends. It depends on whether you're actually using the trademark in commerce and whether or not anyone else has superior rights to that mark. So let's go over what happens when you register a business entity with the Secretary of State. So you submit your papers, you choose a name, you submit your papers, and the Secretary of State will go through the registry of business entities to make sure that your business entity's name is not confusingly similar, although that's not the term they use. But we do use that term in trademark law. It's not confusingly similar to another business entity because we don't want people who are doing business in the state to be confused about which business entity they're doing business with, right? That makes sense. If your business entity's name is too close to another name, then there might be some confusion about, well, who are we actually doing business with? Aside from that, the Secretary of State does not ask, are you actually going to be doing business with this entity, or is it just like a little holding company for you privately? Is it a hobby business? Are you merely getting a business name so that you can set up a separate bank account? They don't care what you're going to do with it. The only inquiry that they make is there another business that's already registered that has a name close to this? If yes, then you have to pick another name. If no, then you get your, your business name registered. Trademarks are totally different. The trademark examiner is very, very interested in your use or bona fide intent to use that mark in commerce. And if you tell the Secretary of State, hey, I have no intention of using this mark, I just want to squat on it, I just want to keep it, I just want to make sure that nobody else can use it, then the trademark examiner is going to say, I'm sorry, you don't have rights to that mark. The only way that you can acquire trademark rights is through either use of the mark in commerce or a bona fide intent to use the mark in commerce. At some point, you are going to have to prove that you are actually using the mark in commerce. And it doesn't matter if no one else is using it, right? We don't care if no one else is using that mark. We only care, are you using the mark? So it's not like the Secretary of the State. The Secretary of State says, yes, you can have it as long as no one else is using it. The Trademark Office says, yes, you can have it as long as no one else is using it and as long as you're actually using it. So there are no squatters' rights in trademark law. Yes, you can register a business name and use that name as a trademark, but only if no one else is using it, common law using it in your geographic area, okay? So there are such things as common law trademark rights that you acquire through use that are good for the area in which the mark is being used. So if nobody else is using that mark in your geographic area, then you can use the mark. Or you can also be prevented from using the mark for your business name if someone else has registered a trademark with the United States Patent and Trademark Office. If they have done that, then they have superior rights to you in every state and territory of the United States, and you will not be given a registration. And if you go ahead and use that mark in commerce, you're very likely to get what I like to call a nastygram. That's a cease and desist letter from the mark owner's attorney telling you to stop using that mark. So again, trademark rights are required through use, and you only have the right to use them, irrespective of your business name, okay? You only have the right to use them if you're actually using it and no one else has superior rights to you. So I hope that clears up the confusion. I'm going to tag the man who asked me about this and let him know that I've answered his question. If you have trademark or business law questions, please feel free to message me on my Trademark Doctor page, facebook.com/Trademark Doctor. You can also find an extensive FAQ at TrademarkDoctor.net. I go live here every weekday to talk about trademark and business matters.